Yes, yes. It's two of you guys now, certain My name is Mosongo. Thank you so much. Your Lordship and your Ladyship. As it is the Sharia, our slogan and motto is that we care for justice. Our intention at all times is to uphold the Constitution and ensure access to justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, not 50 years, but I do stand on the shoulders of giants who have been there before me. And I want to just bring out 5 points in my experience. Why you shouldn't vacate the orders or fail to ensure there is conservatory orders. Number 1, in promoting justice and the interest of justice, we have petitioners who are saying that the right to fair trial and constitutional rights have been contravened and violated. And it will be so painful for them, genuinely speaking, that conservatory orders be lifted, vacated. Then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal placement. Our argument is that the lordships and the ladyship, to ensure that their constitutional rights to fair trial, even including during this process, just preserve the few days that you guys will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest.
Judges are not guides.
My apologies. My apologies. My apologies. The lordships and the ladyships. It is indeed public interest, genuinely, that, and for stability, that for sure status quo be maintained, not only for the current president, vice president, or even the nominee of the president, because you know it said, ukiona cha mwenzako, kitu cha mwenzako kimeelewa, chako kitie maji. It is critical even for future vice presidents, deputy presidents, to have their rights safeguarded, and at least the courts provide a guideline on how Article 145 is to be exercised. And for sure, we also think that and argue that procedural integrity and legal precedent that you are at this point making, the lordships and the ladyship, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately when now you make a finding that for sure the entire process could have been flawed. We argue that to also avoid arguments that possibly there would be potential bias, we encourage the lordship and the ladyship to really consider that, as I wind up, that let's ensure that there are no allegations from both sides that justice was not done. It's imperative that at all times justice be seen to be done in line with Article 159. And lastly, they are arguing, the petitioners, that irreparable harm would be occasioned upon them. And it is in the interest of justice that they be accorded that one final bullet, last chance to be able to benefit their rights before the final outcome of this one. I humbly pray that the lordships and the ladyships, please do not vacate the order. Thank you so much.
Thank you very much, presiding judge and members of the court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may even go half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are. That's where we need to start. What are the facts that are relevant to you determining whether conservatory orders should continue in force or should be vacated? It is my humble submission that the pertinent, the material facts are as follows. On the 17th of October 2024, the Speaker of the Senate gazetted the removal from office of the former Deputy President, the Honorable Rigathi Gachagua, by dint of Article 157, sub-Article 7. It is important for us to go there, my Lord, and it will take half a minute. What is the language of 145, sub-Article 7? It is this: if at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. That's the language. Shall cease to hold office. As at the day and the time and the minute that Senate voted, the Deputy President ceased to hold office. I hope this doesn't disappoint my learned friend Teresia Kimodo of Teresia Kimodo and Company, who wants an apology. The Deputy President ceased to hold office. But something else happened. An intervening fact is that on Friday the 18th of October, via a special sitting of the National Assembly, the Honorable Professor Kindiki Kithure, pursuant to Article 149(1), having been nominated by His Excellency the President, was confirmed by the National Assembly. It voted on his nomination. One person has ceased to hold office, another person has been appointed, has been nominated, and the body entrusted in law in affirming that nomination did so. That was at 1:30 p.m. on Friday the 18th of October 2024. What then did the honorable judges of the High Court of Kenya conserve? What were they conserving? There was nothing to conserve. In the logic of the law, we've been told that a lot about why the Constitution is very important, why it's very special, why it's very transformative, why it's not like the Constitution of other countries. It may very well be all that. But the Constitution is a law to be interpreted the way we interpret all laws. When we read a will, we don't start searching for the spirit of the will, because the will is speaking. It is saying, I leave my assets to my son, to my daughter, to my uncle. So a person reading a will doesn't tell the family, before we read the will, let us capture the spirit of the will. If we read a tenancy agreement, we do not say, let us capture the spirit of the tenancy. The tenancy agreement is speaking on its face until there is an ambiguity, which is the same thing with the Constitution. It says what it says until there is an ambiguity. Where is the ambiguity when the Constitution has said, shall cease to hold office? It is our first submission. There is no ambiguity. There is no reason to search for any other meaning, any other spirit, any other constructiveness. The petitioner is aware of that. There is an affidavit here called supplementary affidavit in support of the petition. What does it say in paragraph 22? In this case, however, Kithure Kindiki was unqualified because he had not been a member of UDA political party for 3 months preceding the nomination. He was ineligible for nomination to the elective position of deputy president under Article 37 on the 18th of October 20, when the vacancy arose. This is not the Attorney General's affidavit, it is the petitioner's affidavit. So that his lawyers may be acting contrary to his express instructions, because he has sworn an affidavit in which he acknowledges that that office became vacant. It is our second submission that when the so-called conservatory orders, and my colleagues will demonstrate that these are not conservatory orders, these were mandatory injunctive orders of a nature not contemplated by the Constitution in this circumstance. At 1:31 p.m., when the conservatory orders both were issued both in Kerogoya and in Nairobi, there was nothing available to conserve. The substratum of their complaint had been overtaken by events. And so much so, my lords, that, and my learned friends will take you through this, there are several judges who were approached to give conservatory orders, including this bench. And you say there are matters here already overtaken by events. That news may not have reached other parts of the country. Very briefly, I will argue the public interest. My lords, this constitution is a constitution to protect everybody. Sometimes it is cited as if it was tailored only to protect a section of the society in Kenya. It is for everybody, including the institutions that it establishes. It is to protect the judiciary. It is to protect the legislature. It is to protect the executive. We are told continuously that the executive is a problem. The executive is a problem. The executive is also protected by law. The president has a power donated by this constitution to nominate a deputy president. He did that. He has the power to send that name to court, to parliament. He did that. Parliament has the power to vote on that vote. It did that. But it is being suggested that that in itself finds no protection under the Constitution. What finds protection in the Constitution is the conservatory order that came from Kerogoya. Yeah. So, a case called Kerogoya. We were told, my lord, and this is true, that the impeachment process is a special process. It's sui generis. It is neither civil nor criminal. It's a process sui generis. That is why, and this cannot be said many times, enough times, that is why the framers of the Constitution do not say that a vice president will be brought to the Supreme Court of Kenya and tried for violations of the Constitution. It is a political process. It goes to a political chamber. Senate sees it as a political body. That's what happens in there. When Dr. Kaminwa says impeachments are never successful in the United States, it is because of the peculiar politics of the United States. Because the impeachment process, even there, is more political than it is here. So we must have fidelity to law, my lords. It is our submission. If you read through the case of Kirero Ngugi, it is in our bundle, and I will not. And if you read the case of Martin Wambora, Kirero Ngugi is instructive. This is what the court said, and I will be very brief. A court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. Thirdly, the rightness doctrine. Actually, much was said about justiciability. This is not new law. This is old law. It is thousands of years law. Thousands of years of English law. The first thing the judge would ask is, what is your course of action? You must have a course of action. The court is not a forum where litigants can hold an academic debate. The judge will always ask, what is your course of action? Okay? Now, so the doctrine of justiciability may sound new, but it is as old as the common law. What is the political question doctrine? We are not going to argue it. But it is actually straightforward that the Constitution recognizes that it has donated power and authority to several institutions. And each institution should keep to its lane. We have developed a constitutional law, or we are developing a constitutional law here, that actually invites contravention of the Constitution. And it is this, that every conceivable social, political, cultural, economic grievance is capable of a constitutional resolution. How is that? How is that? It is not possible. And that is why in our political social system, we have a million other ways of resolving conflict. Not all conflict is justiciable. Not all grievances are amenable to a constitutional solution. Now, let me go to my second last point about I want to take you to the case of County Government of Kisii and two others versus the Independent Electoral Commission. It is a 2024 decision. And this is the last thing I'll say before I invite my colleagues to come in. The gracious lady will not have to bang her gong. This is what the court said in that matter. While guided and applying the foregoing, in this case, the law does not anticipate that the office of the deputy governor shall remain vacant indefinitely for whatever reason. Having so held that gazettement is a mere administrative formality, and taking into consideration the circumstances of the instant case, whereby nomination and approval by the County Assembly of Kisii was undertaken way back in April 2024, it would be unconstitutional to further delay and postpone indefinitely the filling of the vacancy of the office of the deputy governor of Kisii. That's what that court said. Finally, because I'm still within time, the Wajir case shows that our constitution has self-correcting provisions. What happened there, my lord, will remember? Yes. Is that the governor had been impeached. During his impeachment, the deputy governor assumed the high office of governor. He went to court. After a long litigation, the court found his impeachment was wrong. And then the court said, reverse the order. Just to use an expression by my learned friend, I think it was Mr. Kibamo, the law is organized. The heavens didn't come down in Wajir. The law said, go back to your office, and the rest of you go home and do something else. That is how to ensure certainty, predictability, stability. That is what we should have here. We are here. I am told on behalf of the Attorney General to assure you that for as long as this matter is litigated, the law will be observed. If a day comes when anything needs to be reversed, that will be reversed. But for now, the public interest is in continuing. Thank you.
Yes, my lord, your leadership and my lord, let me dive right into my submissions. And I will demonstrate, my lords, that contrary to the submissions made by my learned friends, Articles 47, right together with Articles 50 and Article 25(1)(c) on the right to a fair hearing were complied with. And I will show, my lord, that as of the time that notice was received in Senate by the Speaker on the 9th of October 2024, notices were issued to the petitioner to file all the documents as prescribed and to defend himself to every question that was raised in the National Assembly, which, my lord, you recall, had voted by 282 members to impeach the Deputy President. The right of fair trial, fair administrative action under Article 47, and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted as the dates when the Deputy President would be heard, and that would be the Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged and commenced. And all parties were aware that the Senate investigations would take 2 days. Your Ladyship and my lords, parties were then invited to respond to every allegation. This was a two-tier trial, my lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no brainer. The Senate, as a trial chamber, my lord, Articles 94 and 95, donating powers to Senate and to the National Assembly respectively. The Senate then proceeded to afford an opportunity. And I want to just demonstrate, my lord, that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1. Because the people may either exercise their powers directly or through their elected representatives. So my lord must read the Constitution in the sense that the Constitution then speaks speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My Lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question. That the petitioner participated in the entire trial. Only the petitioner, my lords, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented this case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body. Each senator, considering the allegations and bundles served to every senator prior to the trial. My lords, it was on the 17th, and this is an important distinction. At 2:30 p.m. after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mutembei presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness but did not reach it. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. My lords, there's a curious point here, and this is important, my lords. The provisions of Article 145, 5 and 6, and I want to refer to those articles, provide, my lord, that at an impeachment hearing before Senate, a party may be represented. 145.5, the President or Deputy President shall have the right to appear and be represented before the special committee during investigations. This article was wholly satisfied because the Deputy President was present throughout the trial. But then Article 145, 6, A and B then step in. If the claims have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. My Lord, Senate accorded the Deputy President an opportunity to be heard. How was that accorded, my Lord? That was accorded, my Lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my Lord, he was present during the entire presentation of the case to the National Assembly. But third, my Lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My Lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submissions, and it goes like this. At 5 p.m., my lords, the Deputy President, the Counsel for the Deputy President, Senior Counsel Paul Mutembei, submitted or told Senate that he could not trace his client, but that he had been admitted at Karen Hospital. He neither presented a medical report nor a report from any doctor. And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the Deputy President, my Lord, Counsel and his team, Senior Counsel Paul Mutembei, Eminent Counsel Elisha Boya, and the entire team proceeded to walk out. And why did they proceed to walk out, my Lord? Perhaps they did not read the wording of the Constitution and or the standing orders. Because a person, my Lord, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my Lord, every opportunity was presented to the respondents to present, but they opted, my Lord, not to proceed and not to provide any document to say at that point to, my Lord, confirm, my Lord, at the point that their client or the deputy president, in that matter, was unwell and admitted. Senate then proceeded, my lord, to vote on that question. My lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my lord, under Standing Order 85, senators on a procedural motion may vote by acclamation. That vote was carried and Senate then voted to proceed. My lord, the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we have to proceed, that Senate proceeded, my lord, the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time-bound and were to conclude in 10 days. The last day, my lord, that the proceedings were to conclude was the Saturday, the next day. My lord, unfortunately, Senior Counsel Mutembei, and the Hansard will demonstrate this, my lord, had applied for an adjournment to the following Tuesday. My lord, we have demonstrated that the petitioner dragged the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disappearing. My lords and your leadership, the petitioner had taken part in the cross-examination of all the parties. No case, my lord, has been presented before you that one, there was a violation of the standing orders of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were proffered against the deputy president. My lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend Mr. Masharia made before this court, that there was additional evidence that was entertained by the speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my lord. My lord, that was a substantiation of a charge on economic crimes that failed. Only, my lords, 5 out of the 11 charges proffered against the deputy president petitioner hearing succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my lord. That out of the 6 charges, my lord, the deputy president was convicted on the gross violation of Articles 10(2)(ab), 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is live before this court, my lord, that is on violating his code that requires him to undertake certain functions and undermining the function of the National Security Intelligence Service. Ms. Kimodo of Kimodo and Company Advocates would want the deputy president to apologize on that count. That's a live matter. But my lord, in the grant of conservatory orders, I submit, and this is because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority.
And I was with you, Professor. Professor, we have
on the principles that the court considered, the Supreme Court considered in the Munya case, public interest, I think, on the scales weighed highest. That this court must take into account the import of a conservatory order issued ex parte against public interest. My Lord, this is a country that is built on the Constitution of Kenya in 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the deputy president, my lords and my ladies, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a deputy president sworn in because of the dictates of Article 131 of the Constitution. My lady and my lords, a conservatory order is therefore inconceivable in the terms defined in the Munya case. A conservatory order of the nature issued by Justice Mosongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect me. This court would only use that authority to support the appointment of His Excellency Honorable Professor Kivuleti, so that this country moves to the second level. I would like you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic. My Lord, wherein would his remedies lie, my friend Nyabodi will submit. If it is a salary of 1 month, that would be compensable by damages. If it is a week's salary that is 6 that I should have been or to have been Deputy President, that would be compensated in monetary terms. But this country, my Lord, cannot be at a standstill and be held through litigation, because we need to have that position filled. My Lord, if I move to the other point, my Lord, we have submitted that since every opportunity was accorded to the Deputy President to present his case, and that he failed to present his case, my Lord, every argument before this court by my learned friends on the import of the processes of an impeachment fall on their back. They fall on their back, my Lord, because the authority in my movie Sonko and Nairobi City County Assembly, and again I argued this one. In fact, I was in this matter. In this case, my Lord, the impeachment was upheld. In this case, Michael Mbuvi Sonko had sought to fault the process leading to the impeachment because there were no reasons given for the impeachment. The Court of Appeal rightly stated that 1, there was the Hansard that contained reasons. 2, my Lord, in terms of an impeachment, my Lord, Mike Mbuvi Sonko was challenging the approach where the Senate sat as a whole, as a committee of the whole. The court finding, my Lord, that that is an option that is open to Senate and cannot speak to the lawfulness or otherwise. Council on the other side submitted that there was need for a committee. Senate, in its proceedings, my Lord, in its wisdom, had voted to proceed through the whole House and accorded the petitioner all his rights that were due to him at the initial stage, only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My Lord, we submit, my Lord, that unless the processes of Senate are faulted by my learned friends, that impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, Rigathi Gachagua, stood impeached henceforth. Unfortunately, my lords, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. And that is why we have the law of succession. Rights and remedies then come into question. My Lord, set aside the conservatory orders. Let us move on, my lords. The bigger public interest tilts in favor of the appointment of His Excellency Professor Kithure Kindiki. A very good man. Thank you. Thank you.
My Lord and my lady, my name is Mutembei for the second interested party, and to that end, we have filed a notice of preliminary objection dated of October the year 2024. We have, in addition to that, filed a list and bundle of authorities on that preliminary objection, and that list and bundle is dated the 25th day of October 2024, and pursuant to your directions, those are the bundles, my Lord. I would suggest you hold them close to you because I'll be referring to them shortly. We have, in addition, filed written submissions, skeleton submissions dated the 27th day of October 2024. Before I delve into the PO, my Lord, a suggestion was made to you. I have forgotten to tell you, my Lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my Lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my Lord, is that unless I am mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me while we have raised this PO, and you find that I deserve to be laughed at, it's okay. My Lord, our PO makes only 3 interrelated points. The point number 1, which you'll find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution to confirm whether anything. I'm here to tell you very shortly, my lords, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the President and the Deputy President. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional. But our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the president or the deputy president of the republic. And that is the point made in paragraph 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the president and the deputy president. But if we are wrong in that submission, my lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. Why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lord, are set in paragraph 6 of our submission. And the simple point is this: that our constitution denies this court, the High Court, jurisdiction on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone were to come here and say that he was denied his Article 38, which is a human right under that election. My lord, it is clear by dint of Article 58 of Article 5 that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My lord and friend, Mr. Ngwe talks of the word disease. We are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear: if you have a dispute as to that matter, never mind it has abrogated the entire Bill of Rights, the court you go to is not the High Court, it is the Supreme Court. And property is a matter of the Bill of Rights, Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my lord, I'm here very humbly to tell you, the mere fact that someone has run to use screening, Article 23, Article 165, does not, without no meaning, that this court has jurisdiction to hear that matter. In other words, my lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about Kindiki. So the substratum of the dispute before you is impeachment. And our point, my lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which remind me of Professor Gideon Muige's issue about justiciability, then you have no jurisdiction. Luckily, my Lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you. Which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my Lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bible, my Lord, the Bible of Authorities. We have produced you, or rather before you, extract of the Bomas constitutional, the Bomas draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether this matter should be handled in the court and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other court, including this one. A, Roman 2, disputes arising from the process of the impeachment of the president. So when we were having our debate through the Bomas process, there was a decision, it's there in black and white, that there will be judicial review, not before this court, but in the Supreme Court. Of course, we know, my Lord, the Bomas draft was one of many. The next draft that was generated in that process is at page 7 of our Bible, the harmonized draft constitution. At page 8, again, clause 201 of that draft constitution, it is clear there in Article 201, sub Article 4, that the Supreme Court has, paragraph A, exclusive, at the lines, exclusive. We moved from that document, and luckily, my lords, the bench, to me, should be familiar with this process, to a document that went to the 2005 referendum, which was the worker draft. We have produced it at page 10 of our Bible. This document is special, my lord, in the sense that it was subjected to a referendum before the people of Kenya. And again, you find there, Article 184, Kenyans were still toying with the idea that the courts can interfere in this process. But what I want you to mark again on page 11 is that the court that had been envisioned is the Supreme Court, not the High Court. We all, of course, know that draft was rejected by the people of Kenya, and that must mean, because this is a draft that reached the referendum, that the people of Kenya also rejected this rule of judicial intervention in this problem before you. Why do I say so? The next document is now the official constitution we have today, which is the Constitution of Kenya 2010. And it has no clause conferring jurisdiction on this court or even the Supreme Court. And that rule was always on the table, my lord, but was dropped from the final draft. We must take it that the final decision the people of Kenya made at the referendum of 2010 was that there will be no judicial intervention in the dispute of the nature before you. You are told that we have cited Article 144. Yet it is irrelevant. Let's see shortly whether it's irrelevant. we have produced Article 144 on page 13 of our budget. My lord and my lady, you can only remove the president and the deputy president through two routes. Either the route of Article 144 or Article 145. We are only mentioning 144 to help us answer, in the absence of express jurisdiction, whether there is inferred jurisdiction. And when you check 144, one of the curious rules, it tells you 144 at 144(8) of our Constitution, is that the report of the tribunal shall be final and not subject to appeal, and if the tribunal reports that the president is capable of performing the functions of the office, the speaker shall soon communicate. And of course, it goes on to all that if they find the president is either insane or suffers an infirmity of body, then the Senate shall vote. Something curious here, my lord, that our Senate can vote to retain a president found by a medical tribunal to be insane, and our Constitution says that decision cannot be challenged in any court or tribunal. Those are not my words. But more curiously, this rule is also repeated, my lord, in Article 165. And for me, what is notable, my lord, is the Constitution speaks to an issue once. It has spoken about this issue of 144 in 144(9), and when we go to 165 again, it says this court has jurisdiction to hear an appeal from a tribunal removal from office, except the tribunal under 144. I don't know, but it must count for something that those who drafted our Constitution decided to deny jurisdiction not just once, but twice. So the million-dollar question, my lord, if this court has been denied jurisdiction twice for the process under Article 144, on what basis can it assume jurisdiction for a process under Article 145 in the absence of express conferment of that jurisdiction, and in the face of the multiple ousters I took you through, where the Constitution says in black and white, this matter may be about the Constitution, this matter may be about the Bill of Rights, but the High Court has no jurisdiction. That's what we mean when we say in our keyhole, my lord, that the Supreme Court jurisprudence in this country, I'm addressing you now, on the authority in advisory opinion number 2, I believe, of 2011. I don't know whether Professor Tom Ojiende was involved. But my lord, we are told in that decision that jurisdiction cannot be arrogated through the craft of interpretation. What the petitioner and those in support of his cause are inviting the High Court to do is to arrogate to itself jurisdiction of a dispute or by the impeachment of the president through the craft of interpretation, through the craft of stealth, through the craft of sophistry. Jurisdiction is something the court either has or does not have. It cannot be inferred. Professor Ojiende is telling me other things one must either have or not have. There is no middle ground. But I suppose he wants me to fall into trouble with the court, so I won't mention it. But let's go to the decision in Nixon versus United States, which is at page 20. Again, you are told to laugh at me because this decision is from the 19th century. I will invite you to note it's a decision issued in the year 1993 I was in upper primary school in 1993, and my students say I'm still fairly young. So this is not a decision from the 19th century, my lord. But I also want to point to you, 1993 is so recent, coming from the United States, a country that has had a constitution running for close to 300 years, now and counting. Why this decision is important, my lord, is several reasons. One, it is a decision from the United States Supreme Court. Two, our law on impeachment, and I hope again we have got my good friend Ongoya the decency to agree that it is from the United States Constitution we borrowed Article 144 and 145. Even if you take the rule now in this, Rule 11 here, Rule 11 in this decision of the Senate. So, this decision, to the extent that it comes from the highest court of the country from which we got this idea now before you of impeachment, must surely be persuasive, even if not binding. But more important, it is all about impeachment. What happened in this decision, my lord, is quite interesting. The person who had been impeached was a judge of a federal court in the US. He was sent to prison, but refused to resign from his judicial office. And because in the US, judges hold office for life, to the extent that he refused to resign, it meant the US Treasury was bound to continue paying his salary and emoluments while he was in jail. And of course, that absurdity was not going to be let go. The United States Parliament, called Congress, the House of Representatives, and the Senate, took up impeachment and impeached this judge. But when you follow the holding in this case, my lord, they say at page 20 of our Bible that a controversy is non-justiciable where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department of government, or when you lack judicially discoverable or manageable standards or remedies for resolving it. I don't need to belabor the point. When you read the case, the Mosongo case and the Wagora case, that is exactly what our Supreme Court has said. Following this decision that impeachment is textually committed. Those are not my words. They are the words of the Supreme Court of the US, the Supreme Court of the Republic of Kenya. And my lord, we submit under Article 144, or rather 145, impeachment is textually committed to the Senate. But they also say the language and structure of the Constitution confirm that textual commitment of this dispute. More importantly, which is what the Attorney General, Emeritus Professor Boyege, you go to page 21, my lord, you are told justiciability is also refuted by the lack of finality inherent in exposing the country's political life, particularly if the president were impeached to months or perhaps years of chaos during judicial review of Senate. We already know, I've been telling you how the other side wants to grind the wheels. We are told by the Supreme Court, my lord, this specter of the country being held on tenterhooks as this matter is 40 years, is fought in the Court of Appeals. The average lifespan of a case in our Court of Appeal is 3 to 5 years, the last time I checked. Then going to the Supreme Court, we are being told the political life of a country cannot be held at ransom, awaiting judicial determination. And more importantly, lastly, because my seniors are telling me I've been talking too much, so that I take my seat before they reprimand me, I want to refer you to page 32 of our Bible. And the reason I'm referring it to you, my lord, is many people will genuinely be shocked by this idea that a dispute like this is not justiciable. But there are good policy reasons for it. And if you read our page 32, which is that decision in Nixon versus United States, it tells you in black and white there are sufficient safeguards embedded in the Constitution, including majorities, minimum voting thresholds required at every stage of that process, including the holding of a trial, including calling and cross-examination of witnesses. And because those safeguards, especially at the Senate, are in the nature of a trial, that's why Chief Justice Rankin tells us here that nobody should have to make every weather of the idea that this type of dispute is not justiciable. Lastly, you were told about political question doctrine and many things. I will invite you to note the courts of Kenya endorsed this doctrine as early as 2005. Again, the authorities on page 51 of our Bado. I don't have time to take you through it. We have produced the Mosongo decisions. We have the citations, the quotes we've listed in our written submissions. And what we are telling you, my Lord, when all is said and done, is to do either of two things. Hold you have no jurisdiction. The consequence would be that these petitions must be struck out. The conservatory order must fall by the wayside, having been issued by a court lacking jurisdiction. But if my lords find that too heavy and too radical, and therefore unacceptable to this court, I am giving you the alternative. If we must infer jurisdiction, because that's what you're being asked, let's infer it at the Supreme Court, which is the global practice, so that the matter is held of this nature is handled once and for all without subjecting the country's political life. That is the public interest we have just been told from the Supreme Court of the United States. That's all, unless there's a question for me.
Thank you.
Hello, my name is Mutembei. My name is Milimo. My Lord, I'm here to address you on 3 grounds. Specifically, my Lord, one on public participation. The second issue, my Lord, I'll be addressing you on is fair hearing, with a reference, my Lord, to the National Assembly. And lastly, on the nominee, my Lord, the deputy presidential nominee. My Lord, on the first point of public participation, you shall not pass, my Lord, that there is no one in the petitions before you who has alleged that they were denied an opportunity to participate in the public participation exercise. The second point, my Lord, is that it is common ground to all the parties that public participation was an essential ingredient in the impeachment proceedings. And that is, my Lord, dictated by Article 118B of the Constitution. And my Lord, on the boxes to be ticked in reference to the public participation exercise, I invite you, my Lord, to refer to the Supreme Court BAT decision. And specifically, my Lord, at page 45 of that decision, which we have attached, my Lord, to the first respondent's supplementary list and bundle of authorities, dated 28th of this month. My Lord, the second authority that I will refer you to on matters public participation is the recent authority, my Lord, that was rendered last week by the High Court in the affordable housing decision, my Lord, that is petition number A154 of 2024, and specifically, my Lord, at pages 178 to 179, rather to 184 of that decision. My Lord, if you are to refer to the replying affidavit of the National Assembly, you will note that the National Assembly, my Lord, undertook an unprecedented public participation exercise. None of that nature and magnitude, my Lord, has been undertaken in the history of this country. And my Lord, I will refer you to the annexed public participation report, and specifically, my Lord, at pages 427 to 555 of the replying affidavit of the National Assembly. And my Lord, very quickly, you note that over 224,000 people over 224,000 people were involved in the exercise, where they volunteered to give their views. And out of those, my Lord, you shall note that 65% of the people who rendered their views were in support of the motion.
Is this submission for the lifting of orders or for petition?
My Lord, I'm trying to establish the fact that everywhere that was made, my Lord, on the fact that there was no public.
We have made those letters, but you know, we need to be, because we are all lawyers and judges, we need to be specific to the courts. You know, some of the things that you say here are actually not meant for this court. We've been trying not to intervene, but you know very well that a lot of submissions which have been made here are not for the proceedings, they are meant for another proceeding. So if we can just avoid them, the better for us.
Yes, my Lord, I stand guided. And then
in other words, Mr. Melinda, you may spare us the submission on the sufficiency of the public participation.
Correct. Yes, my Lord, I stand guided, and I was just going, my Lord, to refer you to one authority that we had, my Lord, attached as authority number 1 in the supplementary list of authorities. If you are to look at page 4 of that authority, my Lord, the sufficiency or otherwise of public participation exercise, my Lord, is to be determined at the main trial. And my Lord, therefore, I would agree with you that all I need to do, my Lord, is to refer you to the report that I've indicated, my Lord, that it appears at page 427, specifically the findings, my Lord, to 455 of the replying affidavit. But my Lord, allow me just to pick one thing out of that report. You are particularly, my Lord, referred to one of the constituencies, specifically, my Lord, KO South constituency, where my line colleague, my Lord, raised issues that indeed the figures did not tie. My Lord, first, you shall note that the figures that were quoted by the petition, my Lord, are contained nowhere in the public participation report that have been submitted before. My Lord, I want to believe that my line colleagues got that information from sources other than